Welcome back. We will start with the next subheading, statements by persons who cannot be called as witnesses. When we are talking about statements by persons who cannot be called as witnesses, we are talking about people who cannot be called. They are valid witnesses. There is no question about the validity of the witnesses or the worthiness of the witnesses. Here we are not questioning their worthiness, okay? What we are talking about is they cannot be called. Why? Because of their unavailability. That is it. We are not questioning their authority or worthiness or anything of that sort. We are only talking about they cannot be called as witnesses. Okay? In that we have 4. Now we go to section 32, which talks about them. The number 1 is someone who is dead. Number 2, anyone whose call would result in undue delay to the proceedings. Anyone who is suffering ill health. Anyone who, if called, would result in expensive proceedings. The proceedings would become too expensive. Why? Someone who cannot be found. This is just an addition that I have written. Okay? So who are the witnesses? Who cannot be called? Some person who is dead. Obviously, a dead person cannot be called. Though he is a valid witness, worthy witness, he cannot be called upon. Then anyone, if called, would result in undue delay to the proceedings. If I am going to call one person as a witness and say he is in some place where it would take a long time for him to come and attend the court proceedings. Okay? If I have to invite call such person as a witness, then it would result in undue delay. Forget delay in proceedings. It will, because of him, there will be a delay in proceedings. Undue delay. Then, if again, the next one, if the person is called, it would result in expensive proceedings. Why? Because if that witness has to appear, then lot of money has to be shelled out. The party who is inviting him or the opposite party has to give a lot of money for him to come as a witness. In that case, such a person cannot be called. What is the 4th instance when the person cannot be found? One is person is dead. Next one is person cannot be found. See, there are so many people, when suppose I am getting a witness signed from one person and then he or she shifts the residence. I don't know where the person has gone, so I cannot find the person. So, when I have to call that person as a witness, it will be impossible for me because I will not know where the person is. Understand? So, these are the 4 actual given in the Evidence Act. We can take up this 2 on practical basis. Suffering ill health means anyone who is bedridden. Not otherwise, not just fever or cold or cough or something like that, not a very minor ailment, a major ailment. Again, this will it will cause undue delay to the proceedings. See, now a bedridden person cannot come to the court, right? So even if such person is called as witness, it will be very difficult for that person to come to the court and give evidence and go back and all that. So you can keep this on a practical basis, but these are the 4 which are given in the Evidence Act. Okay. We will further deal with section 32. This is just the beginning of section 32. Just the beginning. Now we go to what is written in section 32. Cases in which statement of relevant fact by person who is dead or cannot be found, etc. is relevant. Now we have seen the 4 types of people who cannot be called as witnesses, but still their evidence becomes relevant. They cannot be called as witnesses, but still the evidence that they have given becomes relevant. Now how is that possible? This is what is explained in section 32. Majority of the cases depend upon this. Based on this, the judges they are able to appraise the evidence given. Okay, so this is very important, where you have to know, because persons who cannot be called, we have seen the 4 instances, but still their evidence becomes relevant. Though the evidence is not given before a court of law, the evidence becomes relevant. Understand? How is it so? First we will see when it relates to the cause of death. When the evidence relates to the cause of death. You would have heard about dying declaration. This is what is mentioned here. Okay, so evidence which relates to the cause of death, it is known as dying declaration. Now dying declaration, when is it deemed to be a dying declaration? When the person is dying. When the person is dying, necessarily doesn't mean that he or she should be in the process of dying and then there is a statement made. It is not like that. Okay, so just before the death, whatever was the statement made by the person dying, understand? That is known as dying declaration. When we say just before, doesn't mean 1 minute, 2 minutes, 3 minutes. That's not a calculation. Okay, there should be a reasonable time. See, the concept of reasonable time is very important in law. If you cannot fathom the reasonable time, then it will become very difficult for you to judge a case. Okay, so just before dying, the person gives a statement. Again, what's a statement? It can be oral or written. Mind you, please remember all these things. You know, it is not that we read in one chapter or one particular section and then we forget all about it. It is not how law works. Okay, so you should remember, evidence which relates to the cause of death is known as dying declaration, and it is made just before the death, and the statement is made by the dying person. Okay, and that statement can be oral or written. Just before, you have to give reasonable time. This is it. And the place of dying declaration. The place of dying declaration. Where should it be made? If it is found somewhere near the place of death. Okay? Not necessary. Why? Place of death, dying declaration doesn't mean somewhere near the place of death. See, if it is a case of suicide or murder or something like that, if it is a case of murder, of course, then it's different. But if it is a case of suicide, or if it is a case of dowry death, if it is a case of suicide or anything like that, probably the statement made by the person, so and so person is responsible for my suicide. Probably it is by the bedside, as we watch in movies. It is on a table or on the dining table or something like that within the house itself or building itself, office, right? Sometimes what happens, as in case of dowry death, we have seen, we know of many reports, right? So the letter goes from the lady to her parents' house saying that I am being harassed in such a way, in all these ways, therefore I am going to commit suicide. But this shall not be suicide, it will be known as a dowry death. Why? Because the death has occurred due to the dowry demand. Therefore, the letter is with the parents, and parents need not necessarily be in the same house. They will not be. So it will be somewhere in some other state or some other town. But just because it is with the parents in the other city or town doesn't mean that it is not a dying declaration. That is also deemed to be a dying declaration. Clear? Only thing what you have to remember is the reasonable time. If a person has written a dying declaration, has written a letter saying that so and so person is responsible, but the death actually occurs probably after the expiry of the effect of the letter. I am being harassed for dowry. Okay, so I am going to commit suicide. Within 7 years of marriage, this letter is written. But the lady commits suicide. Lady, of course, because it's a dowry death. The lady commits suicide after 20-25 years of marriage. Would that amount to suicide note? Would that amount to dying declaration? Obviously not. Right? So you should just analyze it. There is nothing else to this. Okay, then we go to the next one. B. It is made in the course of business. It is made in the course of business. See, here we are talking about evidence relating to the cause of death. That is known as dying declaration. Evidence which is made in the course of business. It can be documentary or oral. If there is a contract between two parties, it is a written contract. If it is a written contract, that document becomes relevant evidence. Why? Because it is made in the course of business. If there is a breach of contract, immediately we go to the court saying that, Your Honor, this is a contract based on which we started working. All of a sudden, the other party committed breach. So, what will be there? It will be in the course of business. I had gotten into a contract and we were in the course of business. We had started work on the basis of the contract. Therefore, it becomes a documentary proof and it is relevant evidence. Even though the contract was made some 1 or 2 years back before the question in dispute arose. You understand? So, before the question in dispute arose. This is very, very important. Sorry, the dispute in question. I'm sorry. The dispute in question arose. But again, here when we are writing this, we should see the reasonable time. How? Because it should not be made during at the time when the dispute arose. See, there is already a contract which has been entered into. Based on the contract, the activity is going on. Then there is a breach. So you file a case. Understand? If there is a contract, after filing the case, if you have to execute this contract, would it have any validity? No. So what you have to do? First, there should already be a documentary proof or oral. Any statement which is made documentarily or orally. And then the dispute in question arose. Then you have the case. So it should be in the course of business. It should not be apart from the business. When we say in the course of business, it should be related to the business. For example, if you are maintaining some accounts. If we are maintaining a separate accounts, at the time when the case has been filed, we write this account, this is the profit, this is the loss, this is what happened, this is what happened, this is what happened. It is not in the course of business. But if it has been made during the course of, it's a normal activity. Normal activity of business. It is a normal activity related to business. Maintaining accounts, normal activity. If I am into trading, then trading becomes a normal activity. Supply, purchase, all these become manufacture. Anything, any activity you take up with regard to business activity, all these become normal activity which happens during the course of the business. It is in the nature of business. See, if I am into the nature of trading with stocks, stock trading becomes the normal activity in the course of business. So if I am maintaining some accounts or some stocks or something with regard to the business, it is in the course of business. But what if I am doing it as a special case? Then it doesn't become in the course of business. So whatever is the statement made in the course of business becomes relevant evidence, though it is not available now, or the person who made this is not available. Someone who cannot be found. We read it, right? So that comes over here. If there is an accounts person who was working in one ABC company, okay, at that time he has prepared a certain statement of accounts. After a few days or after a few months or years or whatever it is, he resigns and goes to some other company. We don't know which company he is gone to. But still, the accounts that he has maintained, the ledgers that he has maintained, the correspondences, the contracts that he has maintained, everything becomes relevant evidence. Even though the person is not available, that's because it was made in the course of business. It was not a special activity. Understand? We go to the next one. C. What does C say? Against the interest of the maker. See, we know what is evidence. Evidence can be for and or against. Am I right? It can be for and or against. Therefore, when we are reading it, the previous two we were reading about for or against. It can be either way. Here it is very specifically against the interest of the maker. If the evidence which is given, the statement, the activity which has been given is against the interest of maker, even then it will be deemed to be relevant evidence. If I am speaking against myself, can the judge say, no, you are speaking against yourself, please don't do that, stop doing that? Will the judge say that? No. The judge will not say that. Why? Because the Evidence Act says, even though it is against the interest of the maker, if there is an evidence which is given, then that evidence shall be relevant. Understand? Then we go to the next one. D. Gives opinion as to public right or custom. Gives opinion as to public right or custom or matters of general interest. Okay, so one thing you should remember is everything has happened before the dispute in question arose. That's the only thing you should remember. For section 32, when you are dealing with section 32, when a person cannot be found, when a person cannot be called upon as a witness, okay, but still the evidence that that person has given becomes relevant. When will it become relevant? Only if the evidence has been given before the dispute in question arose. You should be very, very thorough with this particular sentence. Otherwise, the entire answer that you write for the section 32 will go wrong. Understand? The entire section 32 answer what you are going to write depends upon the fact that even though the evidence was given before the dispute in question arose by a person whom we cannot call as witness, even then the evidence is relevant. If you cannot keep it in your mind, please write it down somewhere, because dispute in question arose, before the dispute in question arose is very, very important sentence. Clear? Yeah. We'll continue with this. Opinion as to public right or custom or matters of general interest. Who will they be? Obviously they will be anyone who has special knowledge of what? Special knowledge of the public right or special knowledge of the custom or matters of general interest. Who are they? We call them as experts. So what are we talking about here? Expert opinion. Understand? So we are talking about expert opinion when we are talking about public right. Right of the public in society. Customs. Immediately our mind goes to community. Matters of general interest. Civic awareness. Nowadays, people are more into, they are aware of what is going on in the society and what has to be done. Even though the governmental authorities are cooperating, residents are taking up upon themselves to do so many activities. Citizens are doing so many activities by themselves with the cooperation of the government, of course. Okay? So in that case, what will happen? General interests. So matters of general interest. So it can be on any topic which is of general interest. So who will be asked about for the suggestion, for the opinion? It will be the expert. Who is an expert? Anyone who has special knowledge about the public right or custom or general interest. Understand? See, sometimes in the media interviews or we have so many debates going on. Okay, so if it is about a public right or some matter about general interest, people from that particular field are called upon to give their opinion. Why do we call people from those particular fields to give their opinion? It is only because of expert opinion. They have special knowledge about the particular general interest or public right or custom. See, when it comes to constitutional questions regarding the constitutionality of certain activity or word or thought or whatever it is, then immediately the constitutional experts are called upon. Right? So that is what I mean to say. The latest, there are so many controversies going on. In that also, the major one being the, I guess it is the Ayodhya issue which is going on now. Okay, in that case also, general interest, it is not a question of public right or custom or anything. It is just a matter of general interest or religious authorities or whatever. So those who are connected, who have special knowledge about the history of the place, shall be called upon to give evidence or what they have written. For example, we have all read history. We have the stories which have been written by Huan Sang or Chanakya or whoever, there are so many people who have visited India and who have lived in India, who have given expert knowledge about what was in India earlier. So all that can be taken into consideration when we are dealing with public right, custom, general interests. Okay, we go to the next one. We go to the next one. Relates to existence of relationship. This will just take some time. It relates to the existence of a relationship. See, this usually it is needed for now, of course, adultery is no more a crime, but still it is a reason for divorce. It's a ground for divorce. So when we are talking about relates to existence of relationship, what immediately comes to our mind is adultery, bigamy. These are all the ones. Apart from that, you have even the Guardian and Wards Act, which will have to establish that the so and so person is the biological father and he has the visitation rights, right? And he is the biological father, he has to give the maintenance. There are some things. So in this case, you don't have to establish exactly that the person is the father. But when it comes to something like adultery, when it comes to something like bigamy, existence of relationship is very, very important, right? Or where there is a question of agency, then where there is a relationship of trust, am I right? Agency, then this person, the principal has to establish that the person is an agent, or the agent has to establish that there is a relationship of principal and agent between them. So every case that you take up, if it requires that evidence should be given regarding the existence of relationship. See, you can take for example even some property matters where there is a case for partition, there is a suit for partition, or there is a P&C case, or there is a declaration and question, anything you can take as an example. But if it requires the question that relationship should be established, there should be evidence for the existence of relationship, then whoever has special knowledge of the relationship, it can be relatives, it can be neighbors, it can be anybody, but they should have special knowledge of the relationship between the parties. Such a person will be called upon, or if they have already written some document or something like that. Say for example, when lawyers write will, they write power of attorney, they write a gift deed. Gift deed is natural love and affection. So when there is a question as to how come the gift deed, say for example Z has given a gift deed in favor of an NGO. What's the relationship between Z and NGO? There is no relationship. But who has to claim it? Anyone who has special knowledge of the relationship. Same way, if Z has given it to Y, then also they have to see. So if it is whether positive or negative, whatever are the types of evidences, if it has to be established, then anyone who has special knowledge of the relationship will be called upon as a witness, or what is the document that has been written by such a person before the dispute in question arose shall be taken up as evidence. Okay, thank you.